The American Legion versus American Humanist Association 2019 is one of the most important Establishment Clause cases decided by the Supreme Court in the 21st century so far. The facts are as follows. In Bladensburg, Maryland, as part of a memorial park honoring veterans, is a 40-foot tall cross, which is the subject of this litigation. Construction on the cross began in 1918, and it was widely described using Christian terms and celebrated in Christian services. In 1961, Maryland National Capital Park and Planning Commission acquired this cross and the land, as well as the responsibility to maintain, repair, and otherwise care for the cross. The commission has spent approximately $117,000 to maintain and repair the cross, and in 2008 it set aside an additional $100,000 for renovations. Several non-Christian residents of Prince George County, Maryland, expressed offense at the cross, which allegedly amounts to governmental affiliation with Christianity. American Humanist Association is a non-profit organization advocating for separation of church and state. Together, American Humanist Association and the individual residents sued the Commission under 42 United States Code paragraph 1983, alleging that the Commission's display and maintenance of the cross violates the Establishment Clause. There are three questions in this case. The first question is, the display and maintenance of the cross unconstitutional? Second question, under what test should the constitutionality of a passive display incorporating religious symbolism be assessed? And number three, does the expenditure of funds to maintain the cross amount to the government's excessive entanglement with religion? So the answer to the first question is no. The display of the cross is not unconstitutional. The answer to the second question is, the appropriate test is presumption of constitutionality and not the Lemon test, meaning if a religious symbol has been around for a long time, it is presumed to be constitutional, and Lemon test is not applicable. And the answer to question number three is no. The expenditure of funds to maintain the cross does not amount to excessive entanglement with religion. In the majority opinion, the court explained that although the cross originated as a Christian symbol, it has also taken on a secular meaning over time. In particular, the cross became a symbol of World War I, as evidenced by its use in the present controversy. The Lemon test, which the court first articulated in 1971 as a way to discern the Establishment Clause violations, does not serve its intended purpose, particularly as applied to religious symbols or monuments. Thus, when the question arises whether to keep a religious monument in place, as opposed to a question whether to put up a new one, there should be a presumption that the monument is constitutional. So this echoes Justice Breyer's concurrent opinion in Van Orten versus Perry, where Justice Breyer stated that if a monument has been around for a long time, removing it would actually indicate bias against religion, an aggressive and hostile stance toward it. Applying this presumption rather than the Lemon test, the court found that the Bladensburg cross does not violate the Establishment Clause because it has historical importance beyond its admitted and natural Christian symbolism. The dissenting opinion in this case was written by Justice Ruth Bader Ginsburg, and she stated that the cross is inherently Christian and its display and maintenance are violations of the Establishment Clause, and her proposed solution would be to return land to private hands, thus avoiding Establishment Clause controversy. Thank you.